My name is Aaron Crawford. I'm with the Center for Presidential History. I'm talking with Leonard Leo of the Federalist Society. To start off, could you give us a little bit about your background, how you became a lawyer, and how you became affiliated with the Federalist Society?
Sure. Well, I've been with the Federalist Society for a little over 20 years, and I first became involved in it when I was in law school. I went to Cornell Law School, and the school did not have a Federalist Society group at the time, and so I set out to form one. And I did that because, in my view, Cornell was dominated by liberal orthodoxy, and there wasn't a balanced set of ideas about the proper role of law in our society. And so I started a group and got to know the Federalist Society very well. And then after graduating and practicing briefly and clerking on the federal courts, I ultimately came to the Federalist Society to help to build out the lawyers' side of its operations. And so the Federalist Society is an infrastructure now of not only law students, but also of lawyers, judges, faculty, business professionals, who basically believe in limited constitutional government. And it's a membership of about 53,000 people. It's come a long way since I first came here almost a quarter century ago, where at the time we were maybe 5,000 members, and it's grown quite sizably since then.
You said you came to build up the lawyer side of the society. Explain exactly what that means, what you did to do that.
Sure. Well, the Federalist Society really started as a reaction to the liberalism that prevailed in America's law schools. So essentially, it began as a way of airing conservative and libertarian legal and constitutional principles on law school campuses. Began in 1982 at Yale and Harvard and University of Chicago, and then slowly grew to cover an increasing number of law school campuses. But there was a point in the mid-1980s when law students who had been involved in the Federalist Society began to graduate. And they wanted to stay in touch. They wanted to stay involved with the Federalist Society. And so a need arose to create some kind of an infrastructure that could accommodate the interests of law students who had graduated who wanted to still do something with the Federalist Society. And so we set out to build, in addition to the law school chapters, a whole infrastructure of lawyers' chapters around the country that could be places where lawyers who believe in traditional constitutional principles could get together, engage in further conversation and debate about legal issues. And then ultimately, we built a network of people who we view as citizen lawyers, people who can go out into the world and foster the application of the principles that the Federalist Society is committed to.
Okay, thank you. Now, a very simple question. When did you first meet George W. Bush?
When did I first meet him? I think we met in, I should have thought about that before the interview. I want to say that we met first when he was governor, but I believe only briefly, and that was it was either in 1999 or early 2000 down in Austin. I was down there to visit with some people I knew connected with the campaign and with his gubernatorial administration. So I don't have a very crisp recollection of the first meeting. But I know I was down there then to talk to key people about issues of judicial selection and legal policy making in a future presidential administration.
So were you involved with the campaign in 2000? In any kind of official
No,
capacity?
not in 2000. In 2000, I recall obviously going down to visit with some key folks on the campaign. I was certainly informally involved with a number of folks on the campaign team. I remember, for example, talking quite regularly with Ted Cruz, who at the time I believe was doing legal policy for the campaign. May have been doing other domestic policy as well, but I remember legal policy. So I know I was in touch with him with some regularity on legal policy issues. And then certainly right after the election, during the whole Bush v. Gore imbroglio, I was very actively involved. And in fact, I took a brief leave from the Federalist Society in order to help organize teams of lawyers to go to Florida for the purpose of helping with canvassing and some of the challenges that were taking place there.
Can you describe some of that work involved with the contested election?
Sure. My main role was to reach out and find lawyers who could take time away from their normal busy schedules to be in Florida for the purpose of helping with whatever recount activity was going to take place. And so initially, I and a few other people basically reached out to our contacts around the country, as you can imagine, because of my work. At the Federalist Society, I knew a lot of people who were lawyers around the country who would be willing to volunteer some time to do this kind of thing. And so we reached out to a lot of different folks and encouraged them to volunteer some time to go down and to help on an as-needed basis. So there was that piece of things, which was really the sort of guts of the whole recount process. And then as time progressed, there were two other needs. One, there were lawyers needed for the various legal teams. As you may recall, there were legal teams sort of run by Ted Olson and George Terwilliger and some others. And from time to time, they needed backup and support from lawyers in terms of research and brief writing. And so we tried to move lawyers into that whole apparatus as well. And then finally, as the whole Bush v. Gore recount and then subsequent litigation became an issue of national prominence, there was a lot of need for media. And of course, because of the technical issues involved, lawyers were particularly in demand with media outlets. And so we, ended up helping to find, lawyers who could be media trained to do a good job of synthesizing the issues and, discussing the matter, on television or radio or in print media.
Just out of curiosity, how many lawyers would we be talking about? How many do you think that you were having to marshal to be involved in this kind of case?
There were, I know I reached out to probably several hundred during that first wave, largely to find out who could make themselves available, what kind of notice they would need, what time frame they were available. How many of those, in fact, went, I would have no recollection, but clearly had gotten commitments from several hundred lawyers to really be at the ready to do what needed to be done. On the media side and on the actual litigation side, far fewer numbers. There you're dealing with people with particular expertise. And so, probably on the media side of things, we, probably worked with somewhere in the neighborhood of about a dozen key lawyers and scholars. And then in terms of actually helping to find talent for the litigation teams, it would be even fewer than that. So the range narrowed considerably.
So this sounds like where the networking really pays off.
Yeah, it does. It does. I mean, it was one where, because of the unique educational mission of the Federalist Society, I had to leave here for that period of time in order to do what I did. But obviously the knowledge I had and some of my friends had of lawyers around the country was very useful. And I think, it shows you the kind of force for good that an infrastructure can have in the community. Lawyers who are basically citizen activists who want to be engaged and want to use their talents and their vocation in a way that advances the public good. And this is one example of it. There are many others too, of course.
Well, the reason we're really here today is to talk about how you were able to step into the process of selecting judicial nominees. And it's turning out to be one of the most important probably aspects of the Bush administration. Could you explain how you became involved in that process of advising on selection to the federal courts, from district courts up to the Supreme Court?
Sure. Well, I should start by saying that it wasn't hard to become involved because in George W. Bush, you had both a presidential candidate and ultimately a president who understood the importance of the judiciary in American public life and who understood that one of the president's most enduring legacies would be the people that he appointed to the federal bench. So it wasn't hard to get involved and to engage him and his team of advisors because he understood the importance of the issue. I suspect he understood it in part because, number one, he, at least through the process of osmosis, saw some of this during his father's administration. Of course, as you may remember, Clarence Thomas was nominated during that time period. That was a particularly brutal confirmation process. And my recollection is that President George W. Bush had some memory of that whole affair. And also, of course, he had been dragged through the courts in connection with Bush v. Gore, and so he had some direct experience with the power that courts can have to make or break our constitutional system. And then finally, he probably also had some recollection of his father's appointment of David Souter to the bench. And as you can imagine, Justice Souter's tenure on the court was viewed by many conservatives as one of disappointment. So he had at least 3, if not more, data points that led him to understand the impact that the federal judiciary could have. So in speaking with him ultimately, but also many of his advisors about this issue, very early on, it was pretty clear to me that George W. Bush was a man who was going to be committed to a sophisticated, strong, intense judicial selection process. Now, some of that may also have been informed by his tenure as governor of Texas, where he also made some appointments, but whatever drove it, it was pretty clear early on, having spoken with Ted Cruz and with Clay Johnson and with other people who were on the campaign, that this was going to be an important aspect of his business of governing as president. So early on in the process, during the campaign itself, I remember having conversations with at least a couple of advisors about how to communicate respecting the proper role of the courts in our society, how to discuss the judicial confirmations and appointments process, what qualities a president would want in a Supreme Court justice. So we had those conversations early on. And then very shortly after the election, I would say literally, days or maybe a week or so, the transition team was already thinking very carefully about judicial selection. Questions, for example, about how the selection process ought to work in the administration. Do we want to adopt a model where the Justice Department plays a lead role or where the White House Counsel's Office plays a lead role? Who are the kinds of people we want to take a look at for various U.S. Court of Appeals vacancies around the country? And I remember having fairly lengthy and explicit conversations with Fred Fielding and Alex Azar, who were on the transition team, about both of those issues. I had some pretty strong views about what the administration ought to focus on, and I have to say I think they did a very good job at the front end. First of all, personnel is policy. I'm sure they heard that from a number of people, not just me, but people like Ed Meese, Attorney General during the Reagan administration, who in a lot of ways was really the architect for an effective judicial selection policy. Personnel is policy. So who you have doing the screening is enormously important. It was pretty clear early on that the White House counsel's office was going to be a critical junction point on judicial selection. And so the White House counsel was going to be very important. The deputy White House counsel, the collection of associate White House counsels, and it was my impression that early on they were selecting people who they thought would have a very keen understanding of what one wanted in a prospective judicial nominee. And so it was not, in my view, happenstance that they picked Tim Flanagan as the deputy White House counsel, who had clerked for Chief Justice Warren Burger, who had been head of the Office of Legal Counsel in the Bush administration. And that office, during the first Bush administration, did an awful lot of vetting for prospective judicial nominees and for Supreme Court nominees. And then if you look at the associate White House counsels who were selected, this was one of the most talented, experienced bunch of lawyers that a White House counsel's office had ever seen. Almost all of them had clerked on the U.S. Supreme Court, for example, and I think virtually all of them, if not all of them, had clerked at least for the U.S. Court of Appeals somewhere or another. So these were people who were not only great lawyers, but who had a lot of experience with judicial personnel, having clerked for them. And that was where a lot of the advising on judicial selection was going to take place. They were very mindful also, though, that the Justice Department was going to have to play a key role, particularly in the post-nomination confirmation process. And so they were very sensitive to making sure that the Office of Legal Policy was staffed in a similar way. Individuals who had, very strong credentials, who understood the proper role of the courts. And so this was the first order of business. And the transition team, I think, did an extraordinary job of assembling a great group of people to help vet prospective judicial nominees for the president. And then, of course, there was the business of starting to come up with that initial list, because there were, of course, vacancies coming off of the Clinton administration. And I had a very strong sense that the president wanted to move quickly. Again, demonstrating his commitment to the role of the courts and understanding the legacy that this has, right? And so very early on, the transition team already sort of sought to find, prospective nominees, looked for, various names, reached out to scholars and experts, myself included, for ideas for people they could nominate to the federal bench, mostly at the U.S. Court of Appeals level. And so that was all pre-inauguration, getting those offices, personnel lined up, coming in with a nice sort of hefty list of prospective nominees that they could then do research on and vet. And so that was how it all really started. And it was a very impressive effort.
Who were some of the people that you worked with in the White House on those selections, and who were some of your suggestions for the court?
Well, in terms of people I worked with, I worked very closely at the front end of the administration with Tim Flanagan with who was the deputy White House counsel at the time, with Brett Kavanaugh, who was one of the associate White House counsels, Helgi Walker, Rachel Brand. I mean, there were a number of folks in the White House counsel's office we worked closely with on judicial nominations. And then Jan Williams, who was my executive assistant, went over to the Office of Presidential Personnel. And while she wasn't directly involved in the judicial selection process, she was involved in helping to staff up the legal policy side. And as you would imagine, a number of those people had some role, if not in the judicial selection process, certainly in legal policy making for the administration. So I worked very closely with Kyle Sampson and Jan Williams in the Office of Presidential Personnel, and then Tim Flanagan and his staff of associate counsels over in the White House counsel's office. Worked to some extent with a couple of folks in the vice president's office as well. Occasionally, David Addington, Shannon Coffin, who was the general counsel to the vice president. The vice president's office had a role to play in judicial selection as well. It became much more pronounced in the context of the Supreme Court process, but they were involved. But Flanagan was really the, I think, on a day-to-day basis, the driver. And he was the one who, when he got there, for example, very early on, he wanted to have very detailed dossiers and memoranda done on any prospective Supreme Court nominee. And so I know that was very much a work in progress that he was involved with. And we tried to help him find people who could, provide background and information as helpful. So that was a legal side. I mean, there's a political side to this too, right? In the sense that I think early on the administration recognized that, judicial confirmations had become contentious going all the way back to 1985, 1984, and there was no reason to believe it was going to be any different for President George W. Bush. So at some point in this process, probably sometime within the first several months of the administration, I and others began having conversations not only with the White House counsel's office and with DOJ, but also with the communications and political side of the executive branch. So Office of Public Liaison, Tim Gagline was the point man there for a lot of this. And then you had Karl Rove himself, who was interested in this issue and had some understanding of the importance of the role of judges because of the work he had done on state Supreme Court races as a political consultant years back. So we began to have conversations with Karl and with Tim as well. And then, of course, as we got into the Supreme Court context later in the administration, that side of the equation became even more pronounced. And it was a collection of people who are on the outside who were involved with this. So in addition to myself, there were three other people who had pretty regular contact with the folks that we've been discussing. Boyden Gray, who was former White House counsel in the first Bush administration, obviously intimately familiar with judicial selection because he did it for the first Bush presidency. Ed Meese, who did it for Reagan, and Jay Sekulow, who was sort of one of the leading public interest litigators in the religious community. So, Jay Sekulow, Boyden Gray, Ed Meese, and I were sort of at some point or another dubbed the Four Horsemen. I don't remember who did this. I know Catherine Cryer talked about it in her book. She was a CNN reporter, correspondent. I don't know, she picked up on it. I can't remember whether she was the one who coined the phrase or whether some smart aleck like Karl did. But somebody came up with this, and the joke was, of course, the four horsemen each had their own sort of corner of the world. Boyden's was business, Jay Sekulo's was religious right, Ed Mises was Reagan coalition, and mine was intellectual purity, since I was the Federalist Society guy. So that was sort of how all this came about. And so we early on had a meeting with at the time, Al Gonzalez, who was the White House counsel, Tim Flanagan, Karl Rove, Tim Gagline. I think it took place in a private room at Morton Steakhouse on Connecticut Avenue in Washington, of course. And that was where we sort of had a conversation about, not the substantive side of judicial selection, as much about what was going to happen when the president, made these nominations, and what kind of fight would we see, and how could we galvanize the interest and attention of the center-right community on judges. And so that was on the political side of the equation. One of the early meetings we had, and the four of us largely played the role of trying to maintain the attention of the conservative movement on the judges issue, both informing them of what was going on, but also really making sure they understood when they needed to be engaged, and when there was an inflection point that required all hands on deck.
Okay, I want to come back to the Four Horsemen thing in just a bit.
Okay.
But I first want to ask about the process, the nomination and confirmation process in the U.S. Senate when the Bush administration began. President Bush named the initial nominees were in May of 2001. So what I'm wondering is what exactly was the talk at the beginning of the administration about the experience of the Clinton administration and the Senate process before the 2000 election? Because some people date this extreme politicization of judicial nominees to the last 4, maybe 6 years of the Clinton administration, and the most famous case probably being the Ronnie White nomination in 1999, which we're now revisiting now. So how did the Clinton experience influence, or did it influence the people making the political decisions in the Bush White House?
Well, it's complicated. I wouldn't say that it was simply the Clinton years that informed the administration on the judicial selection and confirmation process. I think that history informed them going all the way back to 1984 and 1985. That is really when the judges' wars started. Reagan administration, Democrats in the Senate at the time in 84, 85, still in a minority, but giving Reagan judicial nominees a pretty hard time. And then, of course, in 1986, the Senate flips, Democrat control, and all hell breaks loose with the Bork confirmation. In fact, it results in the term Borking, which is to basically, demonize a judicial nominee in the Senate. So those experiences, I think, informed the administration, as well as the Clarence Thomas confirmation process, and essentially put them on notice that everything is up for grabs. There are no rules of engagement on from the other side. It was going to be a real battle. And of course, Bush v. Gore, probably exacerbated the problem because, the left was quite bruised by that whole experience, and felt that they had gotten a raw deal from the U.S. Supreme Court. And so when he came to judicial selection, they were going to take names. And so that first rollout in May of 2001 was going to be really, really important. And the administration knew that. And so it was working very hard to put forward the most impressive, qualified bunch of nominees that they possibly could, knowing full well that no matter how good they were, no matter how diverse they looked, they were going to get attacked. But the best you could do was put forward a collection that at least showed tremendous capacity for judging and for analysis. Extraordinarily well-credentialed people, and so that was in the run-up between January and May. That was what they were doing. They were trying to find the best people possible. And so you had folks like, if I remember correctly, Miguel Estrada and I can't remember whether Bill Pryor was in that first tranche or not, but you had these really distinguished, well-credentialed people. Priscilla Owen on the Texas Supreme Court, some others. And so that they knew they were going to be in for a real battle, no matter who they nominated, and that was based on history going way back. Now, I think the Clinton administration gave them some other insights. Yes, to some degree, the insight that judicial selection was going to be a political hot potato, because it was in the Clinton years. There were a number of nominations, like the Sarakin nomination for the Third Circuit, Ronnie White, a couple of others, where there was a lot of fighting. And I think, again, the Democrats, probably feeling bruised by that, were going to engage in reprisals, right? So there was probably some of that. But actually, there was a different experience that I think people took away. And that was that, to be quite candid with you, Clinton did not do a particularly good job of nominating people to the U.S. Court of Appeals. Number one, he moved, I think, more slowly than would be desirable. And secondly, he did not pick a particularly high-quality group of people in the aggregate. And that's not me saying that. That's the left. At the end of the Clinton administration, Professor Lawrence Tribe of Harvard and others lamented that President Clinton had missed an opportunity to remake the federal judiciary. And so they were, if the Clinton administration gave them any insights, it was, don't miss an opportunity. Take full advantage of the appointment power to help to form the courts in the image that the framers of our Constitution intended. A court that is there to, of course, enforce what's in the Constitution, but not to engage in legislation from the bench in ways that create rights that are not in the Constitution. And so I think that's the takeaway from the later Clinton years. I remember, for example, having a couple of conversations with Tim Flanagan and Al Gonzalez about the importance of really building a talented bench of people on the Court of Appeals, not only because the Court of Appeals are extraordinarily important in terms of the law they lay down, but also because you want to have on the Court of Appeals a bench of talent from which you could potentially pick U.S. Supreme Court nominees. And my own philosophy about that, and I think it was shared by Ed Meese and Boyden Gray and Jay Sekulow, was that your best Supreme Court nominee was one who had prior judicial experience. And so having a good bench of U.S. Court of Appeals judges becomes really, really important.
With the first crop of nominees, It's when you first hear the criticism from many Democratic senators about the administration. Well, the role of the advise and consent role of the Senate with these nominations, and particularly the criticism that they were not consulted. Could you explain a little bit about how the administration may have consulted with the Senate, and also a little bit of your reaction on to their reaction to this first crop of nominees? It became apparent, I think, within a few weeks that this was going to be pretty difficult for several of them, particularly Estrada. Could you explain a little bit about that period?
Sure. First of all, consultation with the Senate has always been a contentious issue. So it was not unique to the Bush administration. You could go all the way back to the Reagan administration, and there were Republican senators who groused and complained that President Reagan picked this or that nominee to the Court of Appeals, and that wasn't the one that the senator wanted, or he wasn't consulted. And those are complaints you hear going way, way back. And that's because, in a way, what President Reagan did was set the precedent that Court of Appeals nominations are really the president's prerogative. He'll take suggestions from senators. Toward the tail end of the selection process, he'll probably call the senator or have someone on his staff call the senator and mention who they're considering. But for the most part, Court of Appeals nominations are within the purview of the president. In contrast with U.S. District Court, trial court nominations, where there's a tremendous amount of latitude and deference accorded to a U.S. senator of the same party. Okay, so consultation, greatly overrated and exaggerated in terms of Court of Appeals nominations. Having said that, my experience was that where there were Republican senators in a home state, they were consulted in the sense that they were told, look, we're coming close to making a nomination. We're looking at these one or two people. We'd welcome any thoughts you have. And if you have other suggestions, we would welcome them. And so there was consultation. Less so with Democrats, as you might imagine, but that's not unusual either. The Clinton administration wasn't engaged in a full-throttle consultation process with Republican senators when he was president. So this is one of those areas where I think there's been some exaggeration on both the Republican and Democrat side in the Senate in terms of, one, how little consultation took place, and secondly, what the history of consultation is in any case. It's particularly amused to hear these criticisms in light of what the president did with regard to California, where he allowed this sort of commission to be established, chaired by Jerry Parsky, who's a supporter of the president's. And it was a bipartisan sort of commission that would make recommendations to the White House. Didn't have any binding quality. But it was a gesture that actually ended up creating quite a good deal of friction regarding all of the California judicial appointments. So while Republicans in the while some Republicans in the Senate maybe, and certainly Democrats in the Senate were complaining about the president not engaging in sufficient consultation. Conservatives were complaining that there was too much consultation taking place in California and perhaps in a couple of other places because of the commission process that had been created there. And so I think it's a red herring.
What is the explanation for the commission, for instance, for California as opposed to other parts of the country? Can you explain a little bit about that? What was the thinking behind that?
My sense is that this was an idea that came from outside the White House, that you had two Democrat senators in California. You had a number of vacancies on the courts in California, and that Jerry Parsky came to the White House with the suggestion of doing this. And I'm not sure they were particularly happy. I'm not sure Al Gonzalez and Tim Flanagan and others in the White House were happy that this was a process they might have to engage on. But ultimately they went ahead with it. And I think it was wrought out of what they viewed as political necessity. That basically with two home state senators who could blue slip, that is to say, hold up any nominee that came forward, there was going to need to be some compromise. The way they ended up doing it, if I remember correctly, is the Court of Appeals nominations were not part of this process. It was only the U.S. District Court nominations, and so that's how they ended up navigating it. I'm not so sure we got much for it. It was a pretty contentious process, nevertheless. I think conservatives generally viewed most of the California nominations as, at the district court level, as less than optimal. And quite frankly, we didn't get anything out of this in terms of comedy on the Court of Appeal side, because the Democrats completely demonized Carolyn Kuhl and earlier Chris Cox. So, I don't think we got much for that deal. And I think that was a lesson that informed the administration on a going forward basis in terms of how much to engage in compromise with Democrat Senate leaders.
Well, with the initial reaction of the Senate to those first nominations, did you become involved in any way trying to sort of break the logjam that sort of developed in the Senate over several of these nominations? And I guess maybe a little explanation for the viewer exactly what the blue slip process is and how that sort of figured into the stalling of several nominations.
Well, first of all, every home state senator, when there's an individual nominated from their state, have the ability to put a hold on that nomination. It's called the blue slip. If you don't return the blue slip, basically you've put a hold on that nominee, and that did happen with a number of judicial nominees, not only at the beginning but throughout the course of the administration. Sure, many of us, played a role in trying to get these nominees unstuck, if you will. Some of that was trying to, galvanize interest and support within the center-right community so that there would be some noise about how unjust it is to hold up a nominee with these kinds of credentials and this kind of record of objectivity and fairness. Sometimes that worked. Sometimes it didn't. But at the end of the day, quite a number of the Court of Appeals nominees did make it through from that first batch. Miguel Estrada, of course, did not. But Carolyn Kuhl did not. But Priscilla Owen and Bill Pryor and a number of the others did. And I think that was a result of the fact that there was just a dogged determination on the part of the president and the administration to stick with these people. And the center-right community saw that, felt it. And when you have an administration that's that committed to holding the line, that's a great way of recruiting outside troops to help engage in the battle. So there were ad campaigns, lots of people calling into the Senate, lots of people doing earned media. I remember there was a particularly famous ad campaign called "Catholics Need Not Apply," which was an ad campaign. I know it was directed at 2 or 3 Roman Catholic nominees. One of them, Bill Pryor, and the assertion was that, the hard left Democrats in the Senate, some of whom, by the way, were Catholic, were holding up these Catholic nominees because they were afraid that they would have sort of political philosophy and social views that would be in contrast with the agenda of the left. Of course, these nominees weren't there to impose their personal agenda. They were there to interpret and apply the law. But since the left doesn't think of the courts that way, they peek behind the curtain to see who you are. You're a Catholic, or you're this, or you're that. And so there was an ad campaign to try to attack some of these Democrats for going after the Catholic nominees. And it was quite an effective ad campaign. It got Senators Leahy and Durbin quite angry.
Well, I guess this is right around the time, the 2002 midterm elections. And I believe that President Bush made the issue of judicial nominations a political issue, probably in an unprecedented fashion. I don't think anyone had really campaigned on this issue like he did. And then, of course, when the Republicans took the Senate in 2003, he renominated several of these nominations that had stalled. Could you kind of explain maybe your involvement in some of that activity? Maybe did you have any connections to the campaigns or any campaigns in 2002, and were you consulted on the renomination of several of these?
President did make it an issue. In a way that no other president in my memory had. And I do think that was of some value. I think, for example, Tom Daschle lost. I can't remember if it was 2002, but that was 4. Okay. But Tom Daschle lost in 2004 in good part on this issue. And I don't think that would have happened without the president having laid a lot of groundwork before then. So I think there's no question that President understood the issue, and I think he knew how to communicate it to a broad population. And I think he understood that there were certain key constituent groups that cared enough about the issue that, they were going to react to it. There's some evidence also, I think, that Clinton was hurt somewhat by some of this and had to deal with it during his own administration. So during his midterm re-election for president, he had a couple of his crazy nominees hung around his neck. And so I think the White House and the president understood that this was an issue that could be turned in the direction of political effectiveness. And so we got a pretty strong cue from the administration that they wanted to engage on this issue. And, once you have a president and administration that wants to talk about this in the context of the midterm elections, it's very easy to galvanize conservative support. get people, to speak out on the subject. And yes, a successful strategy, and for any number of reasons, a turnaround in the Senate made it easier to get a number of these folks appointed.
Well, that leads to the question of the four horsemen. It's after the 2003 election, it seems the administration really began to anticipate the appointment of a Supreme Court nominee.
Yeah.
And a lot of the scholarship now sort of indicates that the four horsemen, you and Mr. Gray, Mr. Sekulow, Mr. Meeks, were sort of a driving force in this process. Can you explain a little bit about what the Four Horsemen's process was?
Sure.
And
Sure.
What were some of the criteria of the judges that you were looking at?
Well, first of all, remember that the four of us had been doing work in the judicial vineyard going way back. So we had a pretty fulsome relationship with this administration on judicial issues going all the way back to 2001. So we didn't just come on the scene post November 04. And I think that's important to bear in mind. So we had some real street credibility with the president and with his advisors on these issues because we had been navigating a lot of judicial selection issues and judicial confirmation issues going back to 01, May of 01, before that. So that gives you some context and background. There's several levels to what we wanted to communicate to the president and to his key advisors. One was, what did you want in a Supreme Court justice? Right, at 35,000 feet, without regard to particular prospective nominees. And there, the question was, what are the criteria? We felt pretty strongly that there needed to be someone with judicial service, what we called a demonstrable judicial record of being committed to interpreting the law and not making it. And we really felt that the only way you could be sure, reasonably sure, about an individual's commitment to constitutional fidelity was to have been a judge for a number of years and to actually have had to write opinions and make decisions. And they are there, and they are, not erasable. They are what they are, and they're contextual. Right. So we, first and foremost, we went to the administration and said, look, you need to pick someone who has a record, demonstrable judicial record. You need to pick someone who's extraordinarily well qualified. Person of integrity, someone who's been tested, battle tested. Going back to the experiences of Bork and Clarence Thomas, you want someone who's going to be an independent, free spirit, who's going to do the right thing regardless of the withering pressure they get from political hacks in Washington, right? So at 35,000 feet, those were things we were communicating to key administration personnel. And they probably knew some, if not all of it, but it's good to reinforce those basic first principles. But we recognize that Supreme Court selection wasn't just going to be a 35,000 foot exercise. We did have views about who ought to be seriously considered. We never went into the White House and said, this is the person you should pick. We made a decision early on that that was not a fruitful exercise. The president was an individual who would not have appreciated that approach, and we recognized that. And so what we wanted to do is we wanted to be honest brokers and advisors. And so we came in and we had a group of people who we thought were worthy of very serious consideration, who we thought would be good Supreme Court justices. There was one very important meeting. I won't be able to confirm the date of that meeting because it's too far back in my memory, but there was a watershed meeting. It was in Andy Card's office. The four horsemen were around the table. And in addition to them, we had Carl and Harriet Myers, White House counsel. There were a couple of clear messages, some of which were welcomed and some of which were not quite welcomed. The 35,000 foot message of how you should go about this, what kinds of qualities you should look for, what we've just discussed in terms of, battle tested, demonstrable judicial record, all of that was sort of listened to with, some degree of respect. And then we said that there were four people who we felt were illustrative of all of those qualities and warranted very, very serious consideration. And those four people were, I believe in the order I don't remember the order that we presented them in at this point. I know that we presented them with John Roberts, Sam Alito, Michael Ludig, Michael McConnell. Those were the four people who we put on the table as worthy of very serious consideration in light of the general standards one would want to apply. We had, however, some discussions before this meeting, just the four horsemen amongst ourselves, whether we wanted to only put forward the names of people who we wanted, or did we want to also make clear that there were certain kinds of nominees that would be potentially troublesome and not necessarily a good idea. And that was a very difficult decision because we knew, as the four horsemen, that we were trying to be helpful to the president. But at the same time, we also knew that we were very likely going to say something which some people weren't going to appreciate and would be offended by. Because essentially what you would be saying is, these are people who meet the criteria and who you should seriously consider, but there are others who don't. So it fell upon me to do the edgier, more confrontational part of the meeting, which was after we had gotten through the niceties of talking about 35,000 feet and the four people who fit those criteria. I then had to lean forward and say, and we also should discuss, the fact that not everyone, of course, is sufficiently qualified to be seriously considered for the Supreme Court. And there were some press stories about some people who were being whose names were being floated. Whether they were being considered or not, we don't know, but we knew the names were being floated. And there was one in particular, and that was Al Gonzalez, who at the time was Attorney General. And we had all said, look, we think very highly of him, but we don't think that's the right. We don't think that's the right candidate for this first vacancy. He doesn't have the federal judicial record that we feel is very important for purposes of this Supreme Court, these Supreme Court vacancies. And that was a contentious part of the meeting. I mean, Carl, I think, was not happy that we laid down that message. My recollection is my reaction to his response was, look, don't shoot the messenger. I'm just telling you, that this is, we're trying to be honest brokers here. This is the reaction you will get from the conservative movement. I mean, we're just being purely analytical about this. This is nothing personal. This is what the conservative movement expects from a Supreme Court, from an administration putting forward a Supreme Court nominee. These are the kinds of people who, in their view, will meet that and deserve strong consideration. These are the kinds of people who don't. And, that's just the way it is. You can do what you want to do, but that's the way it is.
Was the administration seriously considering Gonzalez?
We have no idea. No idea.
What were some of the objections you believe that conservatives would have to Gonzalez? Because many of the press reports made this an issue about abortion, particularly some of his decisions on the Texas Supreme Court.
Yeah. The press made it the issue, the abortion case in Texas. That, in fact, was not what led us to mention his name as potentially problematic for the movement. I mean, yes, we acknowledge that there would be a segment of the movement that would be very concerned about the abortion case. And in fact, Jay Sekulow, and his coalition have been very concerned about that. But, we had looked at the judge's judicial record, and even though he had been on the bench in Texas, he did not have a fulsome complement of decisions. Decisions were not particularly illuminating in terms of what his judicial philosophy was. Not too much of a surprise. I mean, state Supreme Courts, it's hit or miss. Some cases tell you a lot about a person, others don't. And he didn't have a particularly illuminating judicial record from the state bench there. Part of that may have been that he wasn't as senior as other people on the bench, and as a consequence didn't have as much opportunity to write in the big cases. So, our perspective was, look, he might be a great jurist, but we don't know. Not that we know he's not, but that we don't know. And that's a very important distinction which people in writing this history often have misunderstood. It's not that we knew certain people wouldn't be good Supreme Court justices. It was that we know these people would be fabulous because we have a demonstrable record. We don't really know about these people. Why would you want to pick someone who you don't know about or don't know as much about when you have these people over here? And that was the argument we basically made. And it was fine. Everybody, parted the meeting understanding each other's perspectives. Got a little bit contentious, because we were pushing back on someone who was a friend of the president's. But we felt it had to be said. We felt it had to be said. And ultimately, I think it was taken in the spirit with which it was given, which is, look, we care about this president. We love him. We know he cares about the court. We all want to do right by him. We wouldn't be doing our job if we just sugarcoated everything and didn't tell you what we thought the right answers were. And so that's what we did.
Well, of course, the president eventually nominated John Roberts. Can you explain a little bit of your involvement in that confirmation process? And I believe it's at this point, although the Senate confirmation hearings had brought up the influence of the Federalist Society before, it sort of becomes more of a prominent issue during these confirmation hearings. Can you explain a little bit about your involvement and exactly what it was like to be
Sure.
in the Federalist Society at this point?
Sure. Well, first of all, you should understand that at the point of a nomination, I made the decision to take a leave from the society because I was going to be playing a role that, so I took an unpaid leave from the society. I was going to be playing a role that I felt was really not consistent with the sort of the more objective educational mission of the society. This was advocating for a particular Supreme Court nominee, and I didn't want to have the institution tagged with being involved in a direct advocacy effort. We're a membership organization, and I felt uncomfortable binding our institution and its members to a particular position here. So I took a leave. No question that regardless of that, I do think that the nomination, of course, was testament to the fact that the Federalist Society had kind of come of age, in the sense that, I mean, and maybe that was evident from all of the Court of Appeals nominations as well. It probably should have been. I mean, the Federalist Society had been in the vineyard for years, pushing for a restrained judiciary, one that was in line with limited constitutional government. The idea that it's the province of the judiciary to say what the law is, not what it should be. We have been pushing that for years. We have been pushing originalism for years. The idea that the text and original meaning of the Constitution is what matters. Plain meaning in terms of construing laws as opposed to looking to some spirit of the law. That law, legal text had discernible meaning, and that was what the judge was supposed to be applying and interpreting, not making it up as he goes along. And the fact of the matter is that those concepts, those philosophical concepts, were the centerpiece of the Bush judicial selection strategy. So in a way, reaches the public's consciousness when you have a big nomination like a U.S. Supreme Court nomination. And that's when finally, the press said, the Federalist Society has finally come of age, right? Because, who's being nominated to the court? People who espouse this sort of judicial philosophy. So in that respect, I think a lot of the work of the Federalist Society, was culminating in directly in the appointment of people who embraced this restrained judicial philosophy. So there was a lot of question about, well, was Roberts involved in the Federalist Society? Is he not involved in the Federalist Society? It was all rather silly. I mean, the important point was just the president was committed to appointing judges who were going to, as he put it, not legislate from the bench. That was President Bush's phraseology for this. And so that's how it all began. That's not to say that Roberts' selection was free from all doubt. I have a very vivid recollection of a meeting that took place in Harriet Miers' office, White House counsel. She was there with Bill Kelly, Deputy White House counsel. And I remember at some point, Bill stepped out of the office, and Harriet said to me, "So you know, what do you think of Roberts?" And I said, "Well, I think Roberts is a good, strong candidate for the court." And she said to me, "Why?" And I gave, the answer. Well, I think, he's demonstrated fidelity to Constitution's text and to the textual meaning of statutes and laws, and understands the proper judicial role, and that's evidenced in his work. Show me 2 cases that you think show that. I was quite taken aback by this. She really pressed hard in that meeting. She wanted to hear the strongest case for John Roberts being an originalist, a textualist, and someone committed to the limited judicial role. And at the end of it, I'll always remember she said, "Well, I hope you're right." Now, I took that to mean that this is probably the direction things were moving in, and if I really had problems with this, now was the time to say something. But, we had felt that his judicial record was sufficiently clear. And a number of us who knew Roberts knew of his career in the Justice Department and in the White House counsel's office during the Reagan administration. Stuff that a lot of people didn't know until weeks into his confirmation. But we knew, because we knew him. And we knew people he worked with. So we had a good sense of his integrity and the way he thought about the law. And that's what made us comfortable. But the truth of the matter is that, full disclosure, it's all a matter of comparison. So we had made it clear that, in the range of the 4 people we mentioned, Judges Alito and Ludig had a much more fulsome record than Roberts and McConnell. So you do the best you can, but we had those conversations. And I do think the administration was genuinely struggling with, do we have enough information about this individual's commitment to the proper enterprise of judging, be it Roberts or any other prospective nominee.
Well, do you know why the president ultimately did select Roberts instead of the other candidates?
Well, you can't know for sure. I mean, I think I wasn't surprised that he picked John Roberts over the other prospective candidates for the first seat. I wasn't surprised. I wasn't surprised because, number one, I thought from a personality standpoint, they probably got along pretty well. I wasn't in the meeting, I wouldn't know, but knowing John Roberts and knowing the president, I felt that they probably hit it off pretty well. Roberts would have shown, I think, humility, would not have been bombastic and overly talkative, would have had a light sense of humor, but not too much of a backslapping sense of humor. So he would have had, I think, qualities the president would find endearing. I could see how they would get along. And of course, Roberts just had impeccable credentials. D.C. Circuit, second most powerful court in the world, in the country. Great pedigree, in terms of practice of law, clerking on the Supreme Court for Rehnquist. The Chief Justice who had died later, and who was already known to be sick, at least. So great credentials, great personality. Physical appearance was what you would expect from a jurist, accomplished jurist. He just demonstrated the part. So I think none of us were surprised by the pick, based on what we knew both of the president and of then Judge Roberts.
Well, before there was ever a nomination, the Democrats in the Senate had filibustered several appellate court nominees. Did you expect or did you anticipate, I assume the administration anticipated the possibility that a Supreme Court nomination could be filibustered? And was this something that was widely discussed? I know eventually the Gang of 14, the compromise in the Senate, helped put some of those nominations through, but a lot of the press accounts at the time raised the possibility, some would say the distinct possibility, that the wrong nomination could have ended up in the first filibuster of a Supreme Court nominee since Fortas in the 60s. So,
well, and Fortas was technically not a filibuster. And there was discussion about this. Early on, we tried to generate earned media explaining that filibuster of a Supreme Court nominee was unheard of, and Fortas was not a warrant to do it, because we were concerned about this. Now, we didn't think John Roberts was going to have any problem getting confirmed. We weren't really concerned about that. The goal there was to just run up the vote count as high as we possibly could. Because if you could begin to rebuild a system where you had large bipartisan support for a Supreme Court nominee, and of course, as that then confirmed justice wends his way along in his career and makes all of these decisions, right, that are consistent with the original meaning, you can make the point, look, everybody knew what they were getting. They voted for him anyway because he was extraordinarily well qualified and within the mainstream of judicial philosophy. So we really wanted to make sure that there were Democrats as well as Republicans supporting him, to set the precedent that we were back to this mold of, there could be bipartisan support for a Supreme Court nominee who demonstrated fidelity to the constitutional text and original meaning.
How did you work yourself? How did you work in that process of trying to get a more bipartisan?
Well, the key really was to generate our media, and as much of it as possible, that basically had several key thematic components to it. One is what we call the no surprises here nomination, which is just, look, the president said when he was campaigning in 2004 that he was going to nominate someone who wasn't going to legislate from the bench, and who wasn't an activist. He kept his promise. When everybody elected President Bush, they already made the decision about what kind of a judicial nominee they wanted for the Supreme Court, and that decision's been made, and here he is. So the president's just keeping his promise. No news here was a very important message. And in fact, we had an earned media campaign that started months before. Months before the nomination, we were putting out media saying, here's what you can expect President Bush to do in the event of a Supreme Court vacancy. Now, remember, at the time, everyone was thinking Rehnquist, right? But because he was ill, though we had some indications that O'Connor might be going. And we were saying, here's what you can expect. And then when the vacancy and nomination occurred, we said, well, we've been saying all along, this is what the president promised, this is what you can expect, and this is what you got. So no big news here. And that was an important message to put out there. And then beyond that, basically we had sort of two communities to deal with. We had the conservative community. Many of the movement conservatives didn't know John Roberts, so we had to be responsive to questions that they might have about his background. And then, of course, responding to the criticisms of the left, to the extent those existed.
Well, you mentioned a moment ago, it's one of those, I wouldn't say it's probably unanticipated in the administration, but the fact that Justice O'Connor retired, Roberts is nominated, but then Chief Justice Rehnquist passes away, and Roberts' nomination shifted. Did this surprise the administration? And I guess the question here is, at what point did the name of Harriet Miers as a potential nominee first emerge in these discussions?
Harriet's name, to my recollection, did not emerge during the first round. Of that, I'm pretty certain. I mean, there may have been internal discussions about it, but if there were, it was not something that I was privy to. Her name emerged when, after Rehnquist's passing. And I have a pretty good memory of, and this story is told elsewhere. It's in Jan Crawford's book, Supreme Conflict, I think is the name of it. I have a pretty clear memory of how this came up, at least on my radar. I had been in a fairly long meeting with Harriet and with Bill Kelly, the Deputy White House Counsel, regarding prospective female nominees for the High Court. The president clearly wanted to nominate a female. I mean, I don't know if you remember, but on Good Morning America, Laura Bush said something about it. And, president clearly wanted to find the female. And they were having a hard time, for whatever reason, coming up with the right person. It could be that some of the people they wanted took themselves out of consideration. It's hard to know, but basically there were a number of, quote, obvious prospective female nominees who weren't available, okay, for whatever reason. So there was this long meeting. I'd been summoned over to the White House to sit down with them, and we literally went through the name of practically every single woman who served on the federal bench and on state Supreme Courts. Just rapid fire going through them, talking about them, trying to come up with some ideas. And at some point, Harriet gets summoned by the president, so she has to step out of. He's traveling, but he's on the phone, so she just tells Bill and I to stay in her office, and she goes off into the other office and takes the call. And it's then that Bill says to me, well, you see where this is headed. So what do you think of Harriet? I said, for the court? And he says, yeah. I said, well, I don't know. I haven't given it a lot of thought. Don't know what the reaction would be. I mean, she's certainly solid in the sense that she cares deeply about the proper role of the courts, and she's, so she has that predisposition. But I've never given it any thought. So Bill says, well, think about it, and if you want to poke around a bit, let me know what people think. Without, of course, saying it came from them. Feel free. So she comes back in. We finish the meeting. I go back to my office. He calls me and says, don't talk to anybody about this. Don't discuss it. But I still want your perspective. And I said, well, I offered it. I mean, I think she's got the right philosophy. She's got no demonstrable judicial record. It's probably going to be a heavy lift because of that. And then we hang up. And I think about this a bit, and I make the decision that we have to have a longer conversation about this. So I call Bill back late that afternoon and say, hey, Bill, look, maybe we should sit down and talk about this at greater length. And we set up a breakfast meeting for the next morning. I think it was the next morning, out at Tyson's Corner. And we meet for 2.5 hours, just talking through the pros and cons of nominating Harriet for the court. At the conclusion of the meeting, Bill says, you should poke around a bit, see what people think. Do it in a way that's discreet, work it into a list of other prospective nominees, but let's get some intelligence. I do that, and as I think the other narratives report, I get the reaction of, come on, crazy, they're not going to pick her. Not that anybody knows anything about her, they just don't think they're going to pick her. I mean, it's not that, oh, she's terrible, why would they pick her? No, it's just, again, going back to what I said earlier in the interview, people would say, no, they would never pick Harriet Miers because there were so many other people who they knew who had a much more demonstrable judicial record that they would have expected to get picked. It's not that they, at the time, it's not that they disliked her or thought she would be bad. It's just that they didn't know anything about her and they didn't understand why the president would pick her. I knew why the president would pick her. I thought the president would pick her because the president knew her, and the president felt in his heart of hearts that she would dispense the duties of the judicial office in a manner consistent with fidelity to the Constitution and the rule of law. I do think he believed that. And I have no reason to believe that that's not the case. So I did my poking around and came back and reported to Bill that this was going to be, as I had said earlier, a really heavy lift. I mean, nobody knows her. Nobody's willing to sort of take seriously the idea that she's being nominated. You'll be in a bunker for some period of time, probably until after the confirmation hearings. And if she comports herself well during the confirmation hearings, then, it'll probably be smooth sailing. But people are going to have a wait-and-see attitude, was what I warned him of. Which is completely consistent with going all the way back to the very first meeting we had in Andy Card's office. This idea of You got to have a demonstrable judicial record. You have to have some circulation in order for people to sort of accept, right? Remember, stealth nominee has a bad connotation because of David Souter, so there wasn't going to be a whole lot of enthusiasm for that.
Well, the fact that she didn't have the type of experience or paper trail that other nominees would have. I mean, you eventually supported her nomination, but what exactly? How did you reconcile that?
First of all, she did have a bit of a paper trail. She did have a judicial record, so, I mean, you know, and it was not as fulsome as the Court of Appeals records that we had access to with, say, Alito or something like that. But secondly, you know, I did have unique experience with her theory of the role of the judiciary, because she was, for a time, the president's key judge picker. And during the course of that whole experience with her, I witnessed in a very firsthand way how she thought about the enterprise of judging, what she expected from a judicial nominee, what she looked for. Her comments about John Roberts are just one example of that, where, you know, she was clearly concerned about whether there was the evidence that was necessary to be comfortable. So number one, I had seen her thought process about what it takes to be a good jurist, and she, in my view, understood that. Secondly, she didn't want the job, okay? And that is actually important and illuminating. It gets to the point I made earlier about one being battle tested. The reason you want somebody battle tested is so that when they're under withering scrutiny and pressure, they don't really care. She didn't really care what people thought. In other words, she didn't want to be a Supreme Court justice. She was perfectly happy being the White House counsel and then basically slipping into anonymity years after the administration. She didn't care. And that says a lot about a person's character and their ability to basically call them the way they see them. Okay? Which is what you want in a judge. So those are the things that got me over the finish line enough to be able to say, well, I'm not gonna oppose her nomination. Maybe there are other people who feel compelled to oppose her nomination because they don't know her the way I know her, and I respect that. But I'm personally not going to oppose her nomination. I'm going to answer questions. I'm going to talk to people when they want information, when they want evidence. I'm going to do the best I can to give them the information they need to make a more informed judgment. But I'm not going to oppose it. Would it have been my first pick? Well, no. And in fact, it wasn't. I mean, we made it pretty clear quite some time earlier who the people were who we felt strongly about. And she wasn't on that list. And she didn't fit that mold precisely the way we described it or projected it. So no, she wouldn't have been my pick.
But it sounds, sort of safe to assume that you probably more than most kind of anticipated that almost looking glass period where you had conservatives opposing the president on this nomination after supporting him so many years on this issue. So were you surprised that the nomination eventually failed?
No, I was not surprised. I was concerned that that was going to be what happened. I was concerned that that was going to be what happened because, number one, I knew this was not her. She did not view this as her life's vocation. So there was going to come a point at which she was more than happy to throw in the towel. Okay? Big difference between that kind of a person and one who wants to fight to the bitter end. Secondly, the criticism was the criticism ultimately was withering. Okay, withering. And I didn't anticipate the nastiness which preceded her nomination. I knew it was going to be a heavy lift. I knew people were going to be shocked. As I put it to Bill Kelly and Andy Card, it was going to be a heavy lift. The administration was going to be in a bunker. There was going to be a wait and see attitude until the confirmation hearings. It was worse than all of that. Okay, worse than all of that. And once that became apparent to me, and once I started to talk to senators, Republican senators, about their sentiments, some of which were articulated after they had done the personal meeting with her, which usually softens them up, it was clear to me that this was not sustainable. And when you combine that with the fact that the conservative movement was roundly against her. But it wasn't the conservative movement that caused me to believe that she was going to go down. It was the senators. It was the senators. And the proof of that, in my view, the culminating meeting, the meeting which was the most important one, that enabled us to go back to the White House and say with certainty, you have a serious problem on your hands. And again, bear in mind, I never recommended she withdraw. I never recommended they withdraw her. This was a purely analytical exercise. Okay? That's what it was meant to be. Ed Gillespie and I had to go up to see John Cornyn. And that was the culminating meeting. We went up to see Cornyn to get the straight scoop from him and what he thought about the attitude on the Hill. And it was that meeting which brought us to the conclusion that this was just going to be unsustainable. And that was the message that I communicated back to Andy Card, Chief of Staff at the time. So it was really the senators that led me to conclude that this just wasn't going to happen. Now, maybe there was the feedback effects from the conservative movement that caused senators to be where they were. Maybe that is a part of it, but the senators themselves were not in a good spot, and that meant this was doomed at some point or another.
We're kind of running on time. But
by the way, you should know one other thing, which is that Harriet Myers was a very big fan of Samuel Alito. From the very beginning of this process, even before John Roberts was nominated, Harriet was quite taken by then Judge Alito's judicial record and was quite a fan of his. And she pressed for him.
I guess that leads to what would be the final topic here, which is how the administration settled on Alito. And I know they were under a lot of pressure to nominate a woman, but I guess there's some question about why Alito, because he was a far more contentious nominee than John Roberts had been, and the final vote kind of demonstrates that. So what was the thinking on that?
Because Alito was a spectacular pick. I mean, look, ultimately, I can't get into the president and first lady's head about how important it was to have a woman. It was pretty clear to me as a participant in the process, having never confronted the president about it directly, that, there was clearly there were forces at work that were trying to get a woman nominated. I think those forces were the president and the first lady. I'm not absolutely certain, but if they weren't the forces themselves, they certainly weren't dissuading people from thinking in that direction. But there did come a point, it seemed to me, where it was clear that there just wasn't, in their minds, a clear candidate who was female. Now, it's not to say that there weren't women who were qualified. It's to say that for any number of different reasons, the women they wanted weren't available, or those nominations weren't possible at that particular moment in time. There were a lot of different factors that could have led to the fact that there was no particular woman who they could nominate at that point. And so whatever their motivation was, there was no woman who fit the bill for them. And I do think that the president was genuinely committed to putting on the Supreme Court bench individuals who were going to engage in a deep fidelity to the limited judicial role set forth in our Constitution. I think that motivated his selection of John Roberts. I do think that motivated his selection of Harriet Miers. And I think ultimately that's what motivated his selection of Justice Alito. There's also another really important quality in the president's mind, and I think this is what people forget. For him, I think, based on my experience, it's not just about brains, and it's not just about your paper credentials. It's about your commitment to our American constitutional system, and it's about your willingness to implement those constitutional mandates regardless of what the rest of the world thinks of you. He, I think, for example, had a very good relationship with Clarence Thomas precisely for that reason. I think he first met him when his father nominated him. And I think that it's that self-effacing, battle-tested commitment to integrity, regardless of what other people think of you, that he felt was very, very necessary in a Supreme Court justice. You can be the smartest guy on the block. You can have a ream of credentials. But if you're going to stick your finger in the wind to see where people are at a given moment, so you can decide how to reach a decision in a case, that's going to be a problem. And so I think when he saw Sam Alito, he saw a man who only cared about the law. And anyone who knows Sam Alito will tell you that this is a guy who doesn't care about what people think of him. He does his job. He does it fully. He does it well, come what may. And I think that ultimately is what prompted the president to pick him. He had the credentials, to be sure. He had the record. He had demonstrated judicial philosophy. But he also had that, that independence of judgment, that sense of humility, and that willingness to take criticism that I think the president felt was so very important to having integrity on the bench. And, so that was, I don't think it was a difficult, ultimately, I don't think it was a difficult pick in that regard. And Justice Alito has quite faithfully demonstrated that in his jurisprudence.
Okay, well, I want to thank you very much, and we're going to wrap up here. Hopefully,
Okay.
it's not the last conversation we'll have, but thank you very much for.
I hope
for
it was
the
useful.
testimony.
So.
Yes, thank you very much.
Great.